His expert witness told the court that his medical practice was worth exactly $0. Her expert witness said the same practice was worth $1.6 million. The judge had to decide who was telling the truth, and the answer was hiding in plain sight in his own tax returns. This is based on In Remarriage of Brandis, a California Court of Appeal decision from 2015. The husband, Seth Brandis, was a medical doctor who owned his own practice. He and his wife, Marlo, had been married for 22 years. When they divorced in 2009, the biggest fight wasn't about custody or the house. It was about one question: what was his medical practice actually worth? Because whatever that number was, she was entitled to half of it under California's community property law. Before we go further, you need to understand California's community property system. Under California Family Code Section 760, anything acquired during the marriage is community property. That means both spouses own it 50-50. A medical practice built during the marriage? Community property. The goodwill, the value of his reputation, patient base, and location? Community property. Goodwill, in this context, means the intangible value that makes a business worth more than just its equipment and furniture. If patients come back because they trust the doctor, that loyalty is value. This is important because the husband's entire argument was going to be, there's no goodwill. The practice is only worth something because I personally work there. If I left, it would be worth $0. That's a common argument in professional practice divorces, and courts know it's often used to hide value. Keep that in mind as we go through what happened. Both sides hired expert witnesses to value the practice. The husband's expert concluded the practice was worth $0. His reasoning: the practice only had value because Dr. Brandis personally worked there. It had no enterprise goodwill that could be sold. The wife's expert reached a completely different conclusion: $1,643,100. Her expert used something called the Van Camp formula, a method California courts use to calculate professional goodwill. It looks at how much the practice earns above what the professional would make as an employee elsewhere. But here's where it gets interesting. According to court records, the wife's expert discovered something unusual in the financials. The expert compared the husband's compensation over several years. Years before the divorce, Dr. Brandis paid himself between $30,000 and $40,000 per month from a practice. This is normal for a successful medical practice. But then, right around when the divorce was filed, his compensation suddenly dropped to $13,000 per month. Think about that. The practice supposedly had no value, yet had been paying him 3 times as much just a year earlier. The wife's attorney argued this was deliberate. By reducing his own compensation, the husband made the practice look less profitable on paper. Lower profits meant lower valuation. Lower valuation meant less money for his wife. It was financial manipulation disguised as business management. Now, here's the legal principle that destroyed the husband's case: fiduciary duty. Under California Family Code Section 721, spouses have a fiduciary duty to each other regarding community property. That's the same duty a trustee has to a beneficiary, the highest duty recognized by law. This means you must act in good faith. You must provide full disclosure. You cannot manipulate community assets for personal benefit. And this duty continues during divorce proceedings, right up until assets are divided. When you deliberately reduce your practice income to lower its valuation, you're breaching that fiduciary duty. Courts don't take this lightly. The California Court of Appeal reviewed both expert reports. They looked at the evidence, and they made their decision. The court adopted the wife's valuation, $1.6 million. They completely rejected the husband's $0 valuation. In the court's written opinion, they noted that the husband had reduced his compensation below market rate during the divorce proceedings. The court found this was done in bad faith to reduce the practice's apparent value. The exact quote from the decision: substantial evidence supports the finding that Seth manipulated his income during the dissolution proceedings to benefit himself at Marlo's expense. The consequences: wife awarded her community property share of the $1.6 million valuation. Husband ordered to pay sanctions for bad faith conduct. Husband ordered to pay portion of wife's attorney fees. Court made adverse findings affecting other asset divisions. The lie cost him far more than just telling the truth would have. The lesson from the Brandis case: you cannot hide business value by manipulating your own compensation during divorce. Courts have forensic tools. They compare historical data. They recognize patterns. And when they catch you lying, the penalties are severe. If you're going through divorce with a business involved, maintain normal business operations. Don't subtly change your compensation. Be transparent in financial disclosures. Understand that goodwill is community property. Know that experts will examine years of records. The Brandis decision is a landmark case in California family law. It's cited regularly when professional practices are at issue in divorce. If you found this analysis helpful, hit subscribe. I break down real divorce cases every Monday, Wednesday, and Friday, explaining the legal principles that determine who wins and who loses in family court. Next time, we're covering a cryptocurrency case where the husband thought blockchain was anonymous. It wasn't. See you then.